Okay, today we're working on Chapter 5-3, Negligent Torts. Okay, we are going to discuss what is a negligent tort, okay, and how is it different than intentional. So intentional means that it's built right in there. What's intentional? It's committed on purpose, okay? There is some kind of intent involved. Okay, so this is our picture. What's the worst that could happen here? This was our do now from this morning. We said the worst that could happen, this guy is on the ladder. He could fall, he could injure himself, he could injure others, he could potentially damage the property, I guess. He could damage the ladder. Okay, who's at fault here? The ladder company, the guy, the apartment complex? It is definitely his fault. Okay, it was his poor decision making. If this is the maintenance man for the apartment complex, who oversees him and has entrusted him to make better decisions than this? Yeah, the apartment complex. So it is a ladder that is leaning up against because he's like trying to reach up here. I think he's painting. It is not a very intelligent decision, but this is the kind of thing. Now, this is how, and we will talk about this in a little while, this is how McDonald's came to have labels on their coffee that says caution hot coffee, because there were people who would not use common sense, and there was a woman in particular who put the coffee between her legs as she drove away, and it scalded the skin between her legs, and that is why McDonald's, then there was a $1 million lawsuit, and now McDonald's has, but thank you. You don't need to sit here, do you, today? You can sit. Okay, you can just, okay, yeah, good. Thank you very much. Okay. All right, so that is our scenario here. Okay, so we said, what's the worst that can happen? I don't know. We can't even guess what the worst is that could happen. But so what constitutes neglect? What does the word neglect mean? Neglect. Yes. Marcus. Okay, I'm sorry, I can't hear because people are being obnoxious. Yes.
Either purposefully forget or forget.
Okay, forgetting. All right, it's a little more than forgetting. Neglect. If I'm neglectful, if I'm a neglectful parent, I am not properly caring for my child. I'm not feeding him or her. I'm not bathing him or her. I'm not making sure that they're going to the doctor. Okay? Okay, so it is a failure, not completely forgetting. It's sometimes just a failure to take proper care. That's neglect. Okay? So our answer to our essential question is failure to care for properly, as in the old churchyard has been sadly neglected, or there are some severely neglected children. That is a verb. The noun is to state or fact, the state or fact of being uncared for, animals dying through disease or neglect. Okay, so that is our definition of neglect. So what constitutes neglect? What makes up neglect? What would be? I gave you several examples. Cajun has given me some examples. What are other examples of neglect? What's happening here? What is being neglected here? Common sense is being neglected here. Okay? He is putting his own life and the lives of anybody who's walking up and down here in jeopardy. Okay? So he is being neglectful there. All right, very good. So what's your verdict? Britt was driving home late one rainy night after drinking alcohol. Okay, so strike one. She had one working headlight. Strike two. Strike three, it's rainy. So even if she was sober and it was rainy, her one working headlight is going to play against her. Okay? She's speeding down a residential street. That means there's houses on either side. It's like a neighborhood area. Usually about 35-mile-an-hour speed limit, 25 some places. She's going 60. Meanwhile, Yi is slowly backing out of her driveway. Okay, I like the multicultural names here. Yi failed to look both ways. And so Britt rammed into the right rear of Yi's car. Both Britt and Yi were injured, and the cars were severely damaged. Who would have to pay for the damages here? Who is at fault? Are they equally both at fault? Okay, who's she? Okay. Okay. Okay, so Britt is doing more things incorrectly than Yi, but Yi is still somewhat responsible. Okay, if you are using, which we'll talk about in a minute, the foreseeability test, could you foresee something happening, something bad happening, as Britt left all drunk and got in her car with one headlight and slurred her way home and raced home? Could you foresee something bad could happen here? Could you, as you watched her get in the car, would you think in the back of your head, I don't know if that's going to end well? Okay, yeah, you have a kind of an idea. Now, as Yi went out of her driveway, out of her house and got into her car and, got in her car and put her pocketbook over here and put the car in reverse and back down real slow, could you foresee that Yi was going to get slammed into the, by Britt, who was racing down the street in a residential area? No. Yi did not have foreseeability of this event occurring. She was doing almost everything right, just a little bit of wrong. Okay, now, granted, the little bit of wrong got her slammed into by this crazy drunk lady, but, and then now let me change this up a bit. What if she wasn't drunk? What if she was old? Okay, and the car was working fine, the headlights were fine, but this just happened in the neighborhood next to mine, and she's 84, and she was driving, and she mistook the gas for the brake, I don't know, but she came around the corner, she was going probably 55, and she took out a mailbox, she took out a tree, she took out a basketball net, and she crashed into a garage. And she came around the corner, and instead of going this way, she went and right into like houses and all kinds of stuff. So now this woman was just old. She wasn't drunk. Okay, but as these people are in their houses here, they are assuming that they are safe, and it's a residential area, and the speed limit is, I think it's 15 in there. So this woman's coming down this road going much faster than that. So she had some kind of issue. Could they have foreseen that something was going to happen? These people, no. Okay, but this woman and maybe this woman's family, it would be, that would be the question of whether or not she should still have a license. Okay, which she does not anymore. Okay, so that is our what's your verdict. Who will have to pay for the damages? Britt will certainly be responsible, okay, for the injury and the damages. We'll talk about comparative, and we'll talk about those damages in a little bit where he would have money. If Britt might owe you a little bit less. Okay, but we'll talk about that. All right. So we're going to talk about reasonable person standard. We're going to hear this again and again and again. Now, this little cartoon here says, for me, that was totally reasonable. And it's a guy who shot another guy. What no big thing, right? Okay. The reason that this reasonable person standard is based on a hypothetical person. Okay, because Tyler's reason is different than Marcus's reason, is different than Matthew's reasonable. Kiara's reasonable. It's perfectly reasonable for Kiara to wear a horse head around school. Okay? She sees no problem with this. Mr. Fox in the front office probably doesn't think that that's a reasonable thing to do. Okay? So instead of, and then there are some people who feel that it would be reasonable for, students to never talk all day long the entire day and the building to be silent. There are people that believe that. Okay? That is also not reasonable. Well, that is also, it falls outside of this hypothetical reasonable person standard. Okay, so this is just an average person, average care, average skill, average intelligence. Okay, they're not a genius, they're just an average Joe. Okay, and then it's based on what they would consider to be acceptable, reasonable, common sense. Okay, so average person would look at the picture of the guy on the ladder and say, that's pretty stupid. Okay, there are people outside of the box who would go, oh, I never thought of that. I'm going to try that. Okay, there are people that would do that. Yes. Reasonable people would think that. Yes. Reasonable people. But there are people who are not. They fall outside of this. Okay, but anyway, so this reasonable person standard is based on a hypothetical, imaginary, person that is just average. Then we also have the above average people. Okay, so those have above average skills or specialized skills, they have a different duty to society. Okay? For example, a physician, a doctor, has a different responsibility because of the training that they have. Because they are, of a higher level of specialized skill, it is expected that if a person slumps over in a restaurant, that a physician would respond to see if they could be of assistance. Okay? So, if you're sitting in a restaurant and the person at the table next to you slumps over in their plate, what are you going to do other than offer to call 911 and, offer to help, help as much as you could? That is reasonable. That's all that's expected of you. If a person slumps over and there is a doctor available, that doctor is expected. They have a duty to provide, additional, help if they can. Okay, so that's the specialized circumstances. If you are a lifeguard and you are trained in life-saving uh, skills and you see someone drowning, okay, you have an expectation that you would attempt to try and save this person. Okay, first responders, if you are a first responder, an EMT, that kind of thing, you have an additional expectation. Yes. Uh-huh. Uh-huh. Yes, she has an expectation to provide as much support as possible. She doesn't, like, obviously we can't say she has to save the life or anything like that, but she has an expectation if CPR needs to be administered, that kind of thing, she does have those skills. She should be delivering those skills. Okay, especially with first responders. My neighbor is a maternity nurse. Okay, so when we were at a wrestling tournament and a wrestler broke his elbow, okay, he broke the bones that come together and meet at your elbow. She was like, I don't know what to say about it. He's not having a baby, so I can't help him. She has a specialized, area. Now, if somebody dropped over and started to have a baby, she would certainly jump in and help, okay, because she has those skills. So anyway, the reasonable person standard, this has to do with whether or not where your duty is to other people. Okay, when we talk about negligent torts, there must be a duty established, okay, what you owe to the other people, and then a breach of duty, and where we see where there's a violation of that. Okay, so the guy in the picture with the ladder, he owed the duty to not injure other people. Okay, and then when the violation would occur is when he put the ladder up above the stairwell, not a bright thing. Okay. All right, so then we have proximate cause. And when we're looking at, this should actually be here. Here's our duty of care is what we need to establish first, and then our breach of duty, and then our injury, and then we need to see if it was foreseeable, if we can connect the dots between what happened and the circumstances that led up to it. So we have our proximate cause. This exists where the plaintiff is injured as the result of the negligent conduct. Okay. If it was a natural and probable result of the negligent conduct, where that situation where the guy is on the ladder, we can look at that and say it's probably going to end badly for somebody. Okay. But the defendant, the plaintiff, the person that is suing, would have to establish that it was both negligent and that there is a proximate cause. So when that ladder fell down and that guy fell down on top of the person walking up the stairs, they would have to prove that had the ladder not been there, they wouldn't have been injured. That one's a pretty self-explanatory. Okay, so that is proximate cause. We can have more than one proximate cause, and this is our example here. The plaintiff is driving down the road and is suddenly cut off by a person who runs through a stop sign. Okay, the plaintiff slams on the brakes to stop because this idiot ran in front of them. So they slam on their brakes, and then they're rear-ended by another guy who's not paying attention. Okay, now, would they have been rear-ended had they not slammed on their brakes? No. No, they would have just kept driving. So the actual injury, the damage to the car happened here when the guy hit the rear of the car, okay? And it happened, the rear collision happened because the brakes were slammed on, but the brakes were slammed on because this idiot, ran through the stop sign. So we have two proximate causes here, and we do have actual damage. Do you understand? Okay, so if this guy had never run through the stop sign, this would not have happened. And therefore, we can point back to that. Okay, if I throw a book across the classroom and I hit Tiara in the head and I knock her out, okay, what is her actual injury would be? What would her actual damage or actual injury would be what? Yeah, like her concussion or her injury to her head would be the actual injury. Okay? What is the actual cause of the injury? No. I could throw the book and it could not land on her, and then it wouldn't really actually cause any injury. The actual cause is the book hitting her head, right? Okay, the proximate cause would be me throwing the book. Okay, where the connection is, if I hadn't thrown that book, she wouldn't have been hit. Okay, and I could throw, 5 books, and they could not hit anybody, and then we wouldn't have any tort. Okay?
What if they're trying to attack you?
Then that would be intentional. Okay? If I throw the book at you, it's intentional. If I'm so angry that I just throw the book, and it happens to clip Tiara in the head, it's negligent. Okay? I didn't mean to hit her. But my actions were reckless, and as a result of my reckless actions, I hit her in the head. Okay? So proximate cause, you need to be able to establish where the what was the cause, even if it's not directly related. Okay, so the plaintiff in this case could bring action against both drivers. And remember, the plaintiff is the person who is bringing the lawsuit, the person who is injured. Okay, so in this case, it is this car right here. This is the plaintiff. Now, this is not, in this case, there was no in-front collision. But, okay, so the plaintiff could bring action against both drivers, the one who cut her off and the one who rear-ended her. Okay, because they were both part of the accident. Now, in most cases, the guy who ran the stop sign, is he going to go, oh, I'm so sorry, let me get out of my car and write you my information so that you can sue me. Here's my card. I would hope that would be the right thing to do, would be to stop and take responsibility, but most people are gone. Okay, and in Pennsylvania, we're actually a no-fault state because things like this were happening and there was very litigious, like all kinds of lawsuits going on. So we have a no-fault state. So as every person is supposed to have insurance, so if Tyler and Cajun and Tamika are driving, Tyler hits Cajun, Cajun hits Tamika, everybody takes care of, their insurance takes care of their own accident, Now, it throws a little fly in the ointment if Tyler doesn't have insurance. Okay, so now he hit Cajun, let's say Cajun doesn't have insurance. Tyler hit Cajun, she doesn't have insurance. So now Tyler's insurance is going to have to cover some of the damage that happened to Tamika's car. Anyway. Okay. So we have elements of a negligent action. So the defendant owes a duty to the plaintiff. Okay, we have to establish that first. What's the duty that we have? And now, according to the reasonable person standard, we all just have a common sense duty to one another, unless we have, advanced skills. The defendant violated that duty. We have to show that the duty was violated by either, a reckless act or just a negligent act. The plaintiff must suffer an injury as a result of the defendant's violation. Okay, there must be actual injury, actual damage that you can point to and say, this is broken and it didn't used to be. Okay? Now, whether that is a broken heart or a broken face or a broken car, that is something we'll talk about a little bit later. But there must be some actual damage, actual injury. Because you couldn't sue me for throwing a book. You couldn't sue me based on what might have happened. All right? Now, it used to be that you could sue on emotional distress. So if I threw the book and Tiara said, oh my God, I can't go to school anymore because Mrs. Robel might throw a book at me and I'm too scared. It used to be that she could sue for something like that. We don't have that anymore. And all right, the injury was reasonably foreseeable consequence of the defendant's actions. Okay? It is reasonable to say that the guy on the ladder, we can see that that's probably not going anywhere good. We can see that that girl, Britt, when she was driving drunk in the rain, that was not going to go anywhere good. Okay, so that is reasonable to foresee it. So we have to have some way of knowing when I throw the book, it's probably not going to end well. Okay, but sometimes there are just genuine accidents. You're just driving down the road and, a tree falls. Okay, there's nobody to blame with that. Nobody was responsible for that. We will, in our society, try to find someone to blame because we like to sue. Okay? We're a litigious society. But these are the elements of a negligent action. You will need to know these and understand these. Okay? Oops. All right. So, the example, I want you to take a minute, grab a piece of paper. I'll give you actually 3 minutes. I want you to write an example. And it can be anything, just kind of pull it out of the sky, make it up. It can be funny, it can be wacky. An example of a negligent tort, okay? A scenario that is something like the ladder, something like the driver, who was driving too fast, something similar to it, but not an exact, pass those two back. Okay, just jot this down. I want you to write down what the duty of care was owed, what the breach of duty is, okay, what the injury is, and was it foreseeable? Was it something that we could assume or guess that might happen? Okay, I'm going to give you 3 minutes. Okay, so we are doing some examples of our negligent torts. Okay, Marcus wants to give us an example. Go ahead. Okay, and no license.
She had got supposed to straighten this girl's hair.
Okay.
And she said, you're so funny. She put really boiling hot water.
Okay.
And she put it on her head. And it was so hot that it burned her neck.
Burn her neck from the hot
Not
water.
knowingly. So the girl sued her.
Okay, so we have very good example, Marcus. We have an unlicensed cosmetologist. Okay, so now our duty of care. Okay, is there a duty of care? Does this cosmetologist owe a care to the person that's getting? Yes. Okay, so yes, we have a duty of care, and it's a specialized duty because we've gone into a salon and we're assuming that the salon is going to screen the people that are working there and make sure that they're able to do the job that they're expected to do. So we have a specialized duty of care. Do we have a breach of duty? Yeah, we have a violation Okay, because she was an unlicensed, I don't know how to spell that. That looks good though. She was an unlicensed cosmetologist. I don't know how to spell it either. And she was expected, the girl who was being the plaintiff, I guess we'll call her, the plaintiff was expecting for the salon to provide a licensed cosmetologist. Was there injury? Okay, yes, and it was like third-degree burns, we'll say. All right, and then finally we have, was this foreseeable? Could we look at the situation and say, this unlicensed cosmetologist could potentially injure or damage these people? Now, maybe it wasn't a physical damage. Maybe it was just really, really bad hair. Okay, maybe they walked out looking like me. All right, but so anyway, so is it foreseeable that this person could could cause injury? Yeah, I see. It's pretty foreseeable. Okay, now who would be the defendant here? Would it be the girl without the license? Who would be sued? Okay, so we have the plaintiff, the girl whose neck was burned. She's going to be suing someone. Who's she going to sue? The salon. Okay, she's not going to waste her time suing, Rachel for burning her. She's going to sue Golden Door Salon or whatever. She's going to sue the Deeper Pockets. Okay, very good example, Marcus. Thank you. Somebody else. Cajun.
It was a little boy running and jumping over another little boy, and he slaps the little boy in his head with his foot, and the little boy hits. The little boy got hit, falls into the trash can, rolls down the street, and hits a car.
Oh, okay. This is very complicated. Okay, now, when we're talking about children, okay, we have a different duty of care. Who is responsible for the children? Yes, okay, so when we talk about a lawsuit, it would be the parents of the child who was hurt suing whom? Suing the parents of the child, okay? So do we have a duty? Yes, we do have a duty. We have a duty. Now, was the one kid like playing at the other kid's house, or were they just like a neighborhood playing? Okay. Now, tell me this. Was there an exchange of parental control? Did one parent say, I have to go check the laundry. Will you watch, Billy Joe? Because that changes it. So they were just playing. And were both parents there? They were in the house. Okay, so both parents were negligent then. Okay? And how old are these kids? Okay. Yeah. So we do have a duty of care. The parents should be controlling their children or checking in on their children. We do have a breach, yes, because neither parent was out. Neither parent was attending. Okay. Now, we do have injury. We have the kid hit by the car, right? So that's pretty serious. Okay. Is this foreseeable? Is it foreseeable that the kids would, tussle with each other? Sure. Is it foreseeable that as a result of the parents not being there, that the kids would roll down the hill in the trash can and get hit by a car? I mean, now, anything can happen with kids, which is why you should always be there and be attentive. But that's a situation where that's pretty random. That's out on a limb kind of random. It does happen. Now, so that goes back to where is the duty of care? There should be an adult to say probably not a good idea to play leapfrog near the trash cans and the giant hill. Okay, so that goes back to the breach of duty. Now we have a plaintiff and a defendant. We have plaintiff, mother of the kid hit by the car, suing the other woman, right? The other mom. Do we have deep pockets going on here? Is she going to get millions of dollars? Okay, so maybe probably not millions of dollars. Maybe they'll cover the cost of some medical bills and that kind of thing. There it could be a valid lawsuit here. Is there anybody with deeper pockets to go after? The driver of the car. Now, is that driver of a car? Okay, if you're setting up a scenario where there's a hill and the kid's rolling out in the trash can, is that driver of a car expecting? Does he have any reason to expect that a child in a trash can is going to come rolling down? Okay. Now you are, as a driver in Pennsylvania, in any state, you are expected to be able to control your vehicle and stop your vehicle if necessary. I don't know that it could be expected that the driver be looking up. I think just looking on the sides of the road is pretty much your expectation of care. But now, if we entered into other things, if this driver was under the influence, and perhaps we could have maybe something going on here, I don't know. But I think you're pretty much out right here at neither parent was paying attention. Okay? Yes?
It was a guy standing and they was about to arrest him, but he, instead of putting his hands behind his back, he put his hands up and just attacked him and broke 5 of his ribs. And then just like beat him for like no reason. Is that
Well, that's not. No, I mean, potentially there could be a lawsuit there, but the question is, when law enforcement, when they're dealing with anybody who is, potential threat, and so sometimes law enforcement goes over the top. It just depends. It depends on the judge that pulls that case. Hey, stop sitting on my chair like that. You, punky. Don't sit on my chair like that. Okay, another example. We'll do one more. Yeah. Okay. You guys in your hills. Okay, Kira's wearing a horse mask. She's running down the hill. Wow. Okay. Okay. No. You really didn't do anything wrong there. Yeah. 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 There's not much going on there. And that would be intentional tort. She shot you on purpose. Okay. That's no. Okay. Interesting. Matthew.
Alana, the school nurse, when she saw that Principal Brown was choking, she had the duty to help him and do the
Heimlich, okay.
She did not help Principal Brown, for he spilled coffee on his shirt while he was choking, and she didn't want to touch his dirty shirt.
She shouldn't be a nurse, but okay. Okay, good. Okay, so the example is Alana is a school nurse. The principal is choking. Excuse me. The principal is choking. Does she have a duty of care? Absolutely. She has a duty of care. She has a responsibility as a citizen and as a nurse to do what she can to prevent imminent death. Was there a breach? Yes, she did not do her job. Was there injury? I don't know. Did he die?
No, he passed out.
Okay, pass out. He maybe hits his head. I don't know. We'll throw an injury in there. Okay, was it foreseeable? This becomes more of an intentional. Well, it is negligence. Is it foreseeable that she would not have performed the Heimlich? No. And the principal Brown was not responsible um, at all. So yeah, that's a pretty good example here. All right, good stuff. Thank you. Okay, so here is our formula. If we have duty, if we have a breach of duty, if we can find causation, approximate cause, and we have damages, then we have a negligent tort. Okay, but we have to have all four of these to move on. And when we are talking about going to court, when we go in front of a jury or a judge, we have to determine guilt by a preponderance of the evidence instead of working with by beyond a reasonable doubt, which means you are sure, you are almost 99.9% sure that this person did it. We don't have to have that in civil law. We just have to have a little bit more sure than not sure. That's all you have to have in tort law, because we're dealing with money, and it's not the same as dealing with putting a person in jail or putting a person to death, okay? So when we talk about standard of proof, you do need to know this term, preponderance of the evidence. Just know that it's a different standard of proof than beyond a reasonable doubt. Okay. Gross negligence. Okay. Sometimes the negligence is so reckless that it demonstrates gross negligence, okay, as opposed to just ordinary negligence. The example here with Alana, the nurse, that was gross negligence. She saw that guy choking and she said, he's like gross, and I'm not gonna like touch his shirt because that's gross. I'm going to just let him die because that's gross. This is an example here of another gross negligence. Humpty Dumpty, okay, the lawyer says, there's loose mortar, there's no warning signs, you're a victim here of gross negligence. The owner of this wall should have posted signs that said it was potentially dangerous to sit on this wall, Humpty, and therefore we can sue.
Did you clarify that he was an egg?
No.
Why does he look cracked?
Because he sat on a wall, he had a great fall. All the king's horses and all the king's men couldn't put Humpty together again. Okay. Oh, he's an egg. Okay. These are other examples of gross negligence here. Okay. This is an X-ray. This is an actual X-ray. These are our medical scissors. Okay.
What?
Yeah, they're left inside this person. Okay, they did not clear the field after surgery. Now, things like this happen in surgery. They leave gauze. They leave a needle or some kind of there's a staple. Extra staples can be left in people. Okay, those things are accidents. It's a very messy environment. It's whatever, but this is gross negligence. Okay, you need to make sure that you have. They should at the beginning of every surgery they do a count of we have this and this and this, and at the end of the surgery, if we only have these two things, something is missing, and they want to know why this thing is not there, so they want to make sure it's not inside the person. Excuse me. Okay, gross negligence. And then it says, I still can't believe lawyers sue doctors. When I'm done with this 36-hour shift, I'm going to yell at one of them. And he says, you just put this guy's brain into his foot. So then they're saying it's a reference to the fact that doctors work these crazy, crazy hours and are not operating with all of their faculties. So that in and of itself becomes a breach of duty. Okay, exhaustion. When you are tired, you drive the same as you drive when you are under the influence of alcohol. Okay, imagine operating on a person. Okay, and not just being drunk, but being tired. And being so tired that you can't think straight. I don't know if you've ever been that tired. I know you have. I know I have. When you're so tired that you're just like, I know, 2-3 weeks ago, I fell asleep in the back. I was in the middle of a lesson. I was teaching. I was recording, and I was sitting up, and I was sound asleep because I was that exhausted. So you're not operating under the same faculties, and therefore that becomes, in and of itself, just gross negligence to be doing these complex surgeries. Okay. All right. This is another example of gross negligence on a larger scale. This is the Gulf water, the deep horizons, the underwater oil spill, the oil rig. There was negligence involved there. Okay, the equipment had not been properly maintained. The people were not doing their proper checks. Okay, so this oil spill, it resulted in all of this fire and pollutants, and this is the oil that was washing up on the Gulf. Okay, and then here's the extended version. These are the mutants. These are fish with lesions and tumors, shrimp with tumors, and these are eyeless shrimp that are found. Okay, these are shrimp that they're mutant, deformed. Okay, as a result of the chemicals in the water. I just thought that was interesting. Okay, children and negligence. Now, minors are held to a different standard of care than adults. So when we're dealing with children, and these happen to be mine, except for that one, he's my nephew, but I like them, so I put him up there. Okay, these are all mine, except for that one. Okay, so when children do things that are negligent, okay, they are held to a different standard because kids, they operate on a different level. Now, very young minors, okay, under the age of 7 are presumed to be incapable of negligence because everything they do is kind of, they do weird stuff. And they don't think about it, they just do stuff. All of the kids in this picture are very young minors. They're all under the age of 7 in this picture. Okay, that's just to... Well, he's not. Now he is. Now he is. But anyway, they were all under the age of 7. Now, again, they just do, especially this one, they just do crazy stuff. He took a rock and tried to throw it over our house, our 2-story home. He missed, and the rock went through the window. Okay, now, truly, is that negligent? Yeah. Duh. Okay, he didn't mean to throw the rock through the window, but it didn't make it. Is he able to come up with to think it through and say, if I throw this rock at that house, it's probably going to break something? Okay, he's not able to think that way. He saw his brother do it. His brother has a stronger arm. He figured, why can't I? And there you go. Now, it comes back to then, who is responsible for these children? You. Me. Where was I? I was standing right next to him when he did it. And I went, what did you just do? I could not believe this just happened to me. And he looked at me and said, what? I'm sorry. And he was very sorry. He felt really bad about it. But he still could not process it all the way through that. Next time, you just have to throw it harder, he told me. No, next time you don't throw a rock at a house. Over the house, Mom. Over the house. Oh, anyway. But in the middle here, okay, we have the minor being evaluated by people of the same age, mental capacity, and experience. And that's how we justify or we figure out what minors should be held responsible for. Y'all are in that minors category. So from 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, you all are doing things that are equally stupid. I don't know if you know this, but you're doing the equivalent of teenage rock throwing at houses, okay? Vandalization and all that kind of stuff. Kids do things and they think they're funny or they think they're just, goofy or this will be funny, I'll jump off this overpass, okay? They're not thinking it all the way through, all the things that could happen. A couple years ago, a teenager, 15, and a few of his friends, 14 and 13, threw a frozen turkey at a moving car. Okay? Oh, it'll be so funny, we'll throw a turkey. Isn't that hilarious? They thought it was so funny. What they didn't realize, and I truly do believe that they did not think it through, was that this turkey became a projectile. It was moving 80 miles an hour. It went through the windshield. It hit the steering wheel, thank God, and it did not kill the woman. But it shattered every bone in her face. She lost vision in both of her eyes. Okay, her entire life changed like that because these kids thought it was funny. Okay, now, the oldest one, 15, pardon me, he served 3 years in jail, okay, for this crime. And so it is crime, and it is also a tort. It was negligent. Now, who can be held responsible for this, though? The parents, but at 14, 15, 16, don't you have some responsibility too? Okay, so and at that point, can you sue the store that sold the turkey? No. Okay, is it the store owner's responsibility to report? I'm reporting a purchase of a frozen turkey by a 14-year-old. Looks like he's up to no good. No. Okay, so there's no one really to blame here. The parents, the kid said, we're going out to play, basketball up at the school. Goodbye, have a good time. Okay, you assume that your children go out and do things, bless you, and then children do very, very stupid things. Okay, that result in all kinds of whatever nonsense. So there's no one here to blame other than the kids. And once they looked at the situation and they said, other teenagers of the same mental intellect, which is just it's average, like there was nothing, mentally at issue here. It was just a regular old group of teenagers doing regular old dumb teenager stuff. Okay, but they did not see it all the way through, all the things that happened. Okay, so that's why when this course was developed, it's called business law and personal law or something. But I always thought it was interesting because it's not just about business. These are things that you will hopefully think through at a later point. Anyway, so kids under the age of 7 not held responsible for their negligence. Minors, we're going to evaluate and say whether or not they should be held, responsible and to what extent. Yes, ma'am. Yeah, I mean, yeah, that would be the same thing. Like not a great decision, definitely an injury, definitely a breach of duty, breach of care there. But the question comes back to who has the money to, because the tort law is all about, we punish these kids with jail time, but do we have money for them to pay to make up for it? No. Okay, we don't have that money situation. So here's another example here. This is what's it called? Development complex in Florida, and they passed a ban so that kids cannot play outside unless they are attended by the direct control of a responsible adult at all times. Minor children, anyone under the age of 18, minor children, must be under the direct control of an adult at all times. Skateboarding, big wheels, loud, obnoxious toys are prohibited in this development, in this apartment complex. Okay, the reason is, and you can see here, there are parking spaces and there are a big bunch of kids out here. But these kids were darting in front of cars and running out in front of traffic. And so the neighborhood, the drivers, were constantly in fear that they were going to hit one of them, back them over or whatever. The kids were not paying attention. They would ride their little bikes behind the cars, and the drivers wouldn't see. Okay? And the parents were not out and supervising, and that goes back to Cajun's example here. So you begin to wonder, who has the duty of care here? The parents have a duty of care to watch their kids. The drivers have a duty of care to watch what's going on the road. Okay, but that duty of care for the drivers is heightened because kids do dumb things. Okay, my 3-year-old ran right in front of our mail truck. Well, she's not 3 anymore, but when she was, she ran. I'm telling you, she just ran out in the street, and I just happened to grab her by the back of her neck. That mail truck was not paying attention because she was doing her job. She was delivering the mail. Okay, she was just, she was moving maybe like 10 miles an hour. It wasn't fast, but it would have done some damage. So had I not been there, that becomes an issue of who would have been responsible for that. Okay, she was right in front of my house. She was in my driveway because the mail truck comes right up in front of the driveway. Had I not been there to grab her, it would have been my responsibility because she's my child. And the truck driver would have also had some culpability, but it's a question of are the kids being supervised and whatever. Anyway, so I just thought that was kind of interesting that they said, would you take your kids to Walmart and drop them off in the parking lot to play? No. So why is this any different? Now, in this particular case, I don't believe that any of these houses have backyards. It looks like there's a common area in the front. Okay, I don't know how long this went or if it went over. I don't know what the circumstances ended up being, but it was kind of somewhat interesting. Okay. Now, comparative negligence. So we have the next kind are comparative and contributory negligence. Okay, when comparative negligence is when the plaintiff is somewhat at fault for the damages, somewhat at fault for their injuries. Okay, so let's see. Matthew's example where the lady didn't do the Heimlich, the nurse didn't do the Heimlich, no comparative, no contributory damages there. No contributory damages here, okay? With Marcus's example of the woman that went in to get her hair done. No contributory damages. In a very, no, that's not even a good example. The guy on the ladder, let's say the person walking up the stairs, I wouldn't walk up the stairs under a guy on a ladder, so maybe we could say that's a little bit, they contributed to their damage. Okay. Yesterday we had an example during theory of a guy walking on a golf range. Okay, so he's walking in where they're driving balls, and he gets hit with a ball. Okay. Now, does he have any right to sue the guy who hit him with the golf ball? No. Okay, because he's walking on the golf range. He's contributed to his damage. Okay, if he wasn't there, it wouldn't have happened. Now, if you're driving golf balls in your backyard and you hit somebody, different story. But in a golf range, it's assumed that you'll be there. But anyway, if a jury determines that the plaintiff is 40% responsible for their injuries, they would then take that amount. They'd calculate the money. The damages would be, for round numbers, we're using $100,000. Say the plaintiff is 40% at fault. We're going to take that $40,000 and we're going to take it away from what the defendant owes, okay, to the plaintiff. All right, comparative negligence. Oh, this is sorry. This is the same thing. So this is your example here. A common example is jaywalking. So a pedestrian walks across the street, not in the crosswalk, okay, and then they're struck by a car. The driver would be responsible, but only to a point, because these guys are not in their crosswalk. Okay, so they, just by the very nature of being out of the crosswalk, they are putting their lives in jeopardy, and so their money that they would receive from the defendant, the person who hit them with the car, would have been lowered by that, whatever the jury would determine that is. Okay, we were in New York City driving, and my mother was driving, and she would go, I'm sorry, go ahead, excuse me. And I said, oh my God, Mom, just drive. You have to hit them. I said, you just have to keep driving. If you stop, the people walk out. Have you ever driven in New York City? Okay, if you drive in New York City and you slow down even for 1 second, people run out in the street and they walk. And the rule is, if you hesitate, then they'll go. So you have to keep going. It's very serious to jaywalk in Manhattan because you could literally be killed. They will hit you with their car. They will not stop. They will not pass go. They will not collect $200, run you over, and then 6 other people will run you over, and they'll find your body later when there's not as much traffic. Okay, it is really, really intense. So, my mother is, oh my goodness, I'm sorry. She's like a little, whatever. She's like a little Tyrannosaurus Rex. So anyway, my sister, who is bat poop crazy, she got in the car and she drives like a lunatic, and so she managed to get us out of there. But it does. You are literally just, if people jaywalk, you are just, hitting them. They're putting their lives in jeopardy by not being in the crosswalks. Okay. So the next thing is contributory. This is not usually, it's the same idea, but it's saying that the plaintiff was so responsible, okay, like the guy on the golf ball, the guy on the driving range. You're an idiot. You were on a driving range, so of course you got hit by a golf ball. Okay, no case, no damages. All right, this is where we're looking for another example here. I would like to take another couple minutes, come up with another example, but this time I want you to find some example of contributory negligence. Okay, you can work in partners if you want. Just come up with, I'll give you about 5 minutes, 3 minutes, something like that. I want you to come up with an example of contributory negligence, where the other party is a part of the negligence and therefore is going to have their case. All right, so we are going to, no, Tyler's going to go first. Where'd he go? Where'd he go? Tyler, ready? You ready to give your example? Okay, clear. All right, so we were talking about comparative and contributory negligence. And Tyler, you're going to give us your example.
What's that? Wow.
Because I can't hear you.
Can you hear me? Alright, I was at the batting cage. You should answer your phone.
Okay, hold on. DTA. Okay.
I was at the batting cage. And I walked away to go get a baseball, and I got hit with the baseball. So it was my fault, because I walked away.
Okay, so very good. At the batting cage, the batting cage instructor guy tells you to stand at the line. You walk away from the line to go get something, and you are then hit by the ball. So you have contributed to the damage that you received. Therefore, the batting cage is not responsible. Okay. In your original example, you stood at the batting cage line, and the equipment malfunctioned, and you were hit anyway, which was an excellent example of true negligence. The batting cage operator, okay, or the owner, is required to have everything be set to certain levels and standards, and so they were negligent in that, and therefore you would be able to recover damages. So that was a very good example. In this case, you walked over and you did something stupid, and therefore you're not responsible. They're not responsible. Okay, good, very good. Marcus. Okay. Tyler. Nothing? Kiara? Wait, who? Okay.
Oregon was calling her, along with Lady Galadriel. They started arguing, and without knowing, her son went and picked up the sword and stabbed his kneecap.
What is kneecaps?
Okay, so while they were arguing, her son picked up the sword that they were using and stabbed his kneecap. Okay. How old is his son? 2. All right. And so you're saying she contributed to her son's injuries because she was not paying attention to. Okay. So she couldn't sue the owner of the sword because she should have been paying attention to her son. Very good. Good example. Yes, ma'am. Yes, sir.
And one of them is standing right behind the fishing pole.
Okay.
And he goes back and he hurts his lip.
Okay.
And he has to be taken to the hospital because his lip is like this.
Okay. So he stood too close to the other fisherman and was injured as a result of his proximity, or foolishly standing so close to the other guy that's fishing. Okay. Good. Cajun, and then Matthew. Or maybe Matthew.
Lana, who's in my previous example,
The deadbeat nurse, got it.
she's no longer a deputy nurse. She actually helps the principal with doing the Heimlich, but when he spits out what he was choking on, it gets into the printer and it jams itself in, so it damages the printer. But the school can't sue Ilana for the damages because she was helping out the principal.
Okay. It's something, it's not exactly contributory negligence. Contributory negligence would be if he's choking, and then when they remove the object, it's like a matchbox car. Okay? Something ridiculous that he should not have had in his mouth, that he was choking on. Okay? Then he contributed to the fact that he was choking. Do you understand that? So, if he was choking on a Lego instead of like a piece of sandwich, if it's something so kind of out there, that would he would have contributed to his own injury. Okay? Or if he lit a match and he knew that earlier in the day he had doused himself in gasoline. Not a great idea. Okay? Do you see what I'm saying? Like, you have to contribute to your own injury. Okay. Casey, you want to share yours?
And I pushed her and she goes flying into the TV and then the TV blows up.
You can say that, but I don't. How would she have contributed to that?
And she
Aggravated you?
Yeah.
Okay. Okay, that's a good example. If you're both fighting and she aggravated you and you pushed her, then she contributed to her damages as a result of your. I'm sure that it did. I believe you. Okay, good job. I think you guys got this. Okay, let's go. All right, so some states have a mixture of contributory and comparative, where they say if any person is more than 50% at fault. So let's say we established that Cajun's sister, what she said to Cajun was so off our rocker that she was more than 50%. Okay, it was something that she did was so bad that she's more than 50% at fault here. Then Cajun's sister would have no like suit against her, and therefore it would be contributory rather than comparative. This is just saying that it's just not an all or nothing. It varies from state to state. Okay, vicarious liability. We've talked about the word vicarious before, but this is when another person is held responsible for the negligence. It's air conditioning. It's a monster. It's coming to get you. Okay? When another person is held responsible for the negligence of another. So this is oftentimes in an employer-employee relationship. So if the employer, the master, okay, is responsible for the negligent acts of the employee, okay, and the example is an employer may be liable for an accident caused by the employee that is operating a delivery vehicle. Okay, so the employer is at home sleeping. They're not doing anything wrong, but they have entrusted to this employee the responsibility to do X, Y, and Z safely, and so therefore they could be liable. And then we also have the parent-child relationship. My kid crawls in the car, puts down the emergency brake, and my car rolls into the street and causes an accident. I am liable for that. I am vicariously responsible or liable for those injuries. Okay. So in this picture, if I tell you there is vicarious liability happening here, okay, or it's going to happen, vicarious liability, paint me a picture. Tell me a story. What's going on? Kiara? Timothy? Okay. Okay. Okay, But here's what's missing: vicarious liability. Remember, okay, if I'm telling you this guy is going to have, I'm sorry, someone else is vicariously liable for this guy. No, not his girlfriend. What were the two examples I just gave you? Let's go back and look. Here's the words, okay? This applies in an employment context where the employer is responsible for the negligent acts of the employee. Okay, so example, an employer may be liable for an accident caused by an employee as the result of the negligent operation of a delivery vehicle. Okay, so if this is not a delivery vehicle, this is something else. Somebody else paint me a picture. What's going on here? How is this guy going to be causing an accident and causing someone else to be vicariously responsible?
Oh, say, he's leaving work.
Okay.
Boss, whatever. And he just got off work. He just went to the gym too. And he's really thirsty.
Okay.
And then, like, he's not driving the steering wheel. He's staying on.
Okay, we are still missing here. I'll tell you what you're missing. You are missing the fact that this guy has to be driving this car for his boss. His boss has to say to him, go and get, Joe Stevens, go pick him up from the office. Okay? His boss has to have placed him in this driver role and entrusted him with the responsibility of operating this vehicle, and then he is drinking coffee and texting while driving. But even though he did it, the boss could technically be held responsible for the accident and the injuries that ensue. Okay, because the boss should trust somebody who's not going to do that while driving. Okay, that's a vicarious liability. If your garbage collector, if they were picking up the garbage and they drove the truck up on your lawn and ripped your lawn all up and tore down your mailbox, okay? Even though the guy driving the truck did in fact commit the accident, who are you going to call and complain to? Yeah, Waste Management. You're going to be on the phone with Waste Management, and you're going to sue Waste Management for the cost of repairing your front lawn and your mailbox. Okay? Not the driver. Joe Williams that's driving, he will be in trouble by Waste Management, but Waste Management's the one that's going to pay you. Okay, vicarious liability. Do you understand? Are you sure? Okay. Your assignment, should you choose to accept it, and even if you don't, to create an example of negligent tort using photos. Okay? You may not use anything else we've discussed in class. I want you to type up the example, so you're going to give me a list of things like this. Hold on. Like this. Okay, where you say what the duty of care is. So you're going to explain what's going on, describe the duty of care, the breach of duty, the injury, whether or not it's foreseeable, if there is comparative or contributory negligence. You're essentially just doing exactly what we've already done, but we're adding in the element of some pictures. Okay, we have these Photoshop skills. We should be able to use our Photoshop skills now. Okay, so you might have a picture of a background, and then a picture of a squirrel, and then a picture of a dynamite stick. Okay, but you're not looking for one picture. You're looking for individual pictures that you're going to piece together and make into kind of a scene, a scenario. It doesn't have to be, lighting the world on fire, but I want you to demonstrate that you understand the concepts of negligent torts, okay, comparative and contributory negligence, okay? And I am going to ask you just to hang with me for one more thing, because we're going to do strict liability. It will take probably 5 minutes, because it's really not that complicated. But I want to throw this in here too. And then we can officially be done with 5-3. Okay. Hold on one second. Okay, last thing we're going to talk about today is strict liability. In your book on page 93 is a definition of strict liability, and I'm going to put it up here. Okay, this is that we have intentional torts, we have negligent torts, and then we have torts of strict liability. Okay, a defendant can be held liable if he or she is merely engaged in an ultra-hazardous activity. Ultra-hazardous is the key word here. The activity is so inherently dangerous, okay, that even if all of the proper care has been taken to make sure that everybody remains safe, there is no way that you can guarantee that no injury will occur. And then I'm going to give you some examples. Or actually, can you give me an example of something that would be ultra hazardous? Something where even if you do everything you can to control it, there's nothing you can do to be 100% sure something bad isn't going to happen. Yes. I do. I want you to give me an example. Yes. Okay, a roller coaster. Very good. Okay, when you're suspended upside down and you're moving at 80 miles an hour, okay, you can do just about everything to make sure that it's going to be okay, but sometimes it's not. That's ultra hazardous. Okay, now, when you go to Hershey Park, have you ever read the ticket? Do me a favor sometime and read the ticket. On the back side of your Hershey Park ticket is a waiver of liability that says that even if, that says that you cannot sue them, even if you die, okay, because, well, it's a waiver of liability. Let me just say it that way. I don't know exactly what it says. But it's saying that if you fall out of the roller coaster, okay, or something like that, it protects them. Because things do happen. Crazy things happen at Hershey Park. I don't know if they've died, but I was on, do you remember the rotor? Do you remember it's like an anti-gravity, where it spins really fast, and then you stick to the wall? Remember that ride? Or have you ever heard of it? I was on the rotor. They don't have one at Hershey Park anymore. I was on it the day that a kid my own age, we were all kids, they said, now there's a circle on the floor, and then when the floor drops down, you're supposed to get in the middle, and then they raise the floor back up so you can get out of the ride. So you're supposed to stand inside of this circle. Well, the kid went over and stuck his foot between the wall and the floor when the floor started to come up. Well, what do you think happened? Well, yeah, he lost his foot, okay? His foot got stuck. It got mangled and stuck between the wall and the floor. They couldn't tear it out, and it was awful. It was awful, okay? Now, who was at fault there? The kid. It was stupid of the kid. Who else was at fault there? The ride operator. Because the ride operator pushed the button to have the floor come up, even though the idiot kid had his foot stuck there. Okay, so both people were at fault there. Now, in this case, is that Hershey Park's fault? It's their fault for hiring someone who wouldn't pay attention, and I know some of you work at Hershey Park. Okay, so it makes you think, I'm doing all these security checks, this is why. Okay, because some people are just foolish. Yes. Yeah.
So I went there, and then the lady had tased me. She was like, "Oh my God," about like ticket. So it was like in my arm for like 20 minutes, and they didn't know what to do. It was like,
Yikes. Yes. All right. Well, okay. Another example of strict liability, and we'll show a couple of them. Strict liability is anything involving wild animals. So ownership of a tiger rehabilitation center. Okay. Or we have around here, we have Lake Tobias. They have wild animals on their premises. You can have all kinds of cages and locks and things like that, but you cannot control wild animals. And if danger, if an animal escapes or an attack occurs, there is liability there. Because no matter what you do, you are still responsible for the fact that this is a wild animal. You can't control it, okay? And same thing with pit bulls here, okay? And I just use this as an example. But a dangerous animal or even a domesticated animal that has shown wild behavior. So a dog that has been has a history of biting, okay? Or if you own a snake and the snake is a poisonous snake, or a tarantula and it's a poisonous tarantula, you cannot, there's nothing you can do that will remove the liability from you. Okay, if you have a poisonous tarantula and you have it in, 500-gallon tank and there's locks and all kinds of stuff, and somebody dies as a result of that, even if a child gets into that thing and the tarantula kills the child, you are still responsible because it is strict liability. It is ultra hazardous. You cannot control the outcome. Okay, dynamite, okay, or demolition stuff. Any kind of mistake that's made here, you cannot, there's just no way of excusing all of the liability. So if a building implodes or explodes and people are killed, you are held responsible. Okay? That's strict liability. Whoops. All right. What's the worst that could happen here? This is an enclosure. This is a gorilla enclosure. What's the worst that could happen? Okay? Yeah, or I'm feeding this gorilla. Okay? I work there. I know what I'm supposed to do, and I have on my protective suit, and I open the right door and everything else. I am still taking a chance with that guy, okay? Because that gorilla, he's bigger than me, and he's ferocious, okay? How about this? Okay, when you're bungee jumping, even if the equipment is correctly prepped, you're still taking a chance. You just are. You could get a bad bounce, and you could hit the rocks. Okay? If the equipment was not thoroughly checked, then it becomes a negligent tort. All right. Now, that is strict liability. Does anybody have any questions about strict liability? Okay, so then your assignment, like I said, should you choose to accept it or not, is to create an example of a negligent tort, and I'll say / strict liability tort, but no intentional torts. Strict liability or negligent torts. Okay, the ones that we discussed today, using that Photoshop idea that I said, and you have to type it up so that it looks something like this. So we at least list out the duty of care, the breach of duty, the injury, whether or not it was foreseeable, and comparative contributory negligence. Yes?
So if you want to do it like that, and then on each page, start with one page, start with duty of care, and go to the next page. Have it lined out, and then...
You should really just have one page. It should just be your picture page and then your list. And, your explanation of your tort can go on your list page. Okay? All right.